Earlier today, a lady almost ran me over in her car, whilst I was on a zebra crossing, I might add. But not only that, she almost ran over another lady who's also crossing the crossing at the same time as me. And so whilst we were both trying to cross the road, we obviously had to stop because the car went straight in front of us. The lady and I exchanged a few looks and a few words about the car and the way she was driving it. One thing that makes this really interesting, if it wasn't enough of a story already, that the vehicle crossed our path as we were crossing the crossing, when she must stop by the way, is the fact that it's a supermarket car park. Now this got me to thinking, because whilst I say it was a zebra crossing, it was in the sense that the zebra lines were painted on the road and it was clear for all to see, but obviously they weren't the normal beacons that you would get at a normal pedestrian zebra crossing. However, this raises the discussion as to whether those kind of markings have any real effect on a car park. So that's what I'm talking about in this video. So if you get into a debate or a quiz about this over Christmas, you can look all clever, quote the law, and thank me for watching my videos. So yes, indeed, many people think that supermarkets don't have the normal rules of the road that you would find on any other road, but I'm about to make that all come crashing down if that's what you thought. Because you have to be very careful when you think about what is a road and whether the rules apply to that road, because if you think a place isn't a road and not covered by the law, you might be mistaken. It still might be a public place, a place to which the public have access, such as a supermarket car park. Now, the law in England and Wales for a road and such public places is section 192, subsection 1 of the Road Traffic Act 1988, which defines what a road is. Broadly speaking, it's any highway, which is any kind of normal road that you would expect, any other road to which the public has access. Now, when you go onto a supermarket car park, there are obviously roads that weave in and out of the parking spaces. That is a road of sorts. It is a road because it is designed for cars to travel along it. It is therefore a road to which the public has access. And by the way, it also applies to bridges over which a road passes. The specific wording given to the definition of a road in the Road Traffic Act is, in relation to England and Wales, meaning any highway and any other road to which the public has access and includes bridges over which a road passes. And in relation to Scotland, for our Scottish friends, means any road within the meaning of the Road Scotland Act 1984 and any other way to which the public has access and includes bridges over which a road passes. So, as you can see, broadly speaking, the same thing. But full disclosure, I don't practice in Scotland. That's a whole other interesting legal trivia, which is best saved for another video. Now, there are a few cases that have been decided in court, common law if you will. If you want to know more about common law, I'll link some videos in the description below if I remember to do so. If I don't, shout at me because I usually forget. But you might be thinking about highways and what is a highway? Well, a highway and a road is pretty much anything to which the public has access. All public roads are obviously a highway, but this includes public footpaths, public bridleways, public driftways, but also public carriageways and public footways. All broad generic descriptions of pretty much the same thing. Any public stretch of something to which the public has access to traverse either on foot or by a vehicle. Many people have had the debate as to whether or not a pavement is part of a road. Well, I will clear that up for you right now. This was decided and adjudicated in Price and DPP in 1990. A pavement is part of a road. Other people might ask about a privately owned caravan park. Well, again, because the public have access to this area, this was decided in Barrett and DPP in 2009. A road in a privately owned caravan park is a road for the purposes of the legislation. Believe it or not, even Trafalgar Square has come to court for a judge to decide whether or not, in the judge's interpretation, in the court's interpretation, whether or not Trafalgar Square is a road, and the court said, yes, Trafalgar Square is a road. This was in Sadiku and DPP in the year 2000. I've heard many people debate whether the grass verge along a roadside is also part of the road, and this is correct. That was decided in Worth and Brooks in 1959, believe it or not. But also cycle lanes, cul-de-sacs and marketplaces. The cul-de-sac being decided back in 1960 and the marketplace being decided in 1964. In fact, the courts have decided that it's much broader than that. Roads are anywhere that the general public has access, not just a special class of general public. and the public have access at least by the tolerance of the owner or the proprietor of that road. Some further examples include a road to a farm which is maintained by the farmer. That was decided in Harrison and Hill in 1932. A housing estate road that is used by the general public. That was decided in Adams and the Commission of Police in 1980. Roads at an airport. That was decided in DPP and Cargo Handling Limited in 1992. The forecourt of a hotel used to reach the hotel as a shortcut by members of the public. This was decided in 1940. A lane on a council estate, also debated by many people, is also considered to be a road, even if it's been used by members of the public just as a cut-through. There are some fairly narrow exceptions to that which is not a road, but to which the public may still have access. So these very narrow exceptions might include a housing estate road which is only used by residents and their visitors. That was decided in 1976. Some lanes that are only used by police or tradesmen or postmen and so on. Roads in the docks, roads inside a factory, and service roads which is maintained by the specific properties on that road. That was decided more recently in 2011. So coming full circle to address the question whether or not a supermarket car park is a road for the purposes of the legislation, the answer is it depends. Because many sources you will find will reference a case called Griffin and Squires in 1958, which ultimately, on the face of it, makes it look like a car park isn't a road for the purposes of the legislation. However, when we look at the actual wording of the judgment and the reasoning behind it, the court held that it was a question for the magistrates who heard this particular case before the divisional court as to whether that particular car park could be treated as a road in the ordinary sense. In that case, the magistrates had decided that it was not a road. Therefore, no offence had been committed in that particular circumstance. However, given that the court in Squires had merely upheld the fact that the magistrates had determined that it was not a road in that particular case, does not necessarily mean that all car parks everywhere are not going to be a road or decided to be a road for the purposes of the legislation. In other words, if a new case came to court on a different car park somewhere else in a different set of circumstances, and the question was put to magistrates again or to a district judge, say, as to whether or not this car park was a road for the purposes of the legislation, the court might come to a different decision, in which case this authority doesn't necessarily bind all car parks everywhere, just that if the decision has been made, then the decision is not going to be tampered with. But as I said, you have to be very careful when considering whether something is a road as to whether the legislation applies to that road, because it may well be, and if you're on it, probably is in most cases still a public place. Some places are not, such as the car park to a pub. When it's closed, it becomes a closed place and it's not open to the public, therefore it's not a public place. Also, the car park at a private club is not a public place because the public don't have unfettered access to that place, therefore it's not a public place. However, a supermarket car park will be a public place. Now, this is important because when you're driving your vehicle, you can still be charged with various offences if you are driving your vehicle carelessly, dangerously, or in any other way that causes danger to other people. Now, talking about the car park that I was on, which has a zebra crossing, which ostensibly is a crossing for pedestrians to use to cross around, whilst it won't necessarily attract the full force of the highway code not being a road, I can tell you with some degree of certainty that if that lady driving the vehicle had have driven into me and or the other lady crossing the crossing, she would likely have been prosecuted successfully for careless or dangerous driving, because she's driving her road in a public place, and if she drove into either of us on what is ostensibly a crossing to all parties concerned, she'd be in trouble. There is also very helpfully an annex to the official highway code which talks about what is a road, public place and where these rules apply. The annex provides that most of the provisions of the highway code apply on all roads throughout Great Britain, although there are some exceptions. The definition of a road in England and Wales is any highway and any other road to which the public has access and includes bridges over which a road passes. That's the bit that I mentioned to you. And it also addresses the position in Scotland. It then says, it is important to note that references to road therefore generally include footpaths, bridleways and cycle tracks, and many roadways and driveways on private land, including many car parks. In most cases, the law will apply to them and there may be additional rules for particular paths or ways. Some serious driving offences, including drink driving offences, also apply to all public places, for example, public car parks. So in summary, there you have it. If you are on a car park that is open to the public, not a private car park, which is only open to its members, so in this case, a supermarket car park, you should assume that all of the rules of the Highway Code will apply, and all of the offences that are covered within the Highway Code and in other legislation will also apply. That will include drink driving, drug driving, careless driving, dangerous driving, and all of these sorts of things. And I can near enough guarantee you, as I said, that if a vehicle drives into somebody on what is ostensibly a crossing on a supermarket car park, they will be prosecuted and quite likely successfully. So as I said, if you end up in a debate over all this, those are my views, those are my interpretations from the Highway Code, the legislation, and what I think will happen in court. I hope you found that interesting. Please do like the video and subscribe. That really helps my channel grow, and I thank you all so much for watching.